Good afternoon, everyone. Today is Thursday, October 22nd, 2020. Thank you for joining us for the virtual town hall for the city of Menifee. It has been presented today by Fair Housing Council of Riverside County in partnership with the city of Menifee. This activity is being presented today under the auspice of Fair Housing Initiative Program Education and Outreach Federal Grant from the Department of Housing and Urban Development. My name is Jamila Reed, and I serve as a testing coordinator and fair housing investigator for Fair Housing Council of Riverside County. Before that, I was a fair housing tester for 2 years with the purpose of determining whether housing providers and others are complying with the Federal Fair Housing Act. So let me briefly introduce our panelists. Senior Management Analyst Edna Lebron has been with the City of Menifee since February 6, 2017. Ms. Lebron came from the City of Hemet, where she served for almost 17 years as the housing technician and later was promoted to a housing specialist. She brings with her 20 years of public service experience. Currently, Ms. Lebron administers the Community Development Block Grant and the CDBG CV1 and the CDBG CV3 and the Minor Home Rehabilitation Grant programs from the City of Menifee. From the Fair Housing Council, we have Richard Lemire, who is a testing coordinator and fair housing investigator. Richard Lemire joined Fair Housing Council in 2015. Prior to that, Richard was a public and information specialist for Community Action Partnership of Riverside County, where he was responsible for all community and media relations. He is also a past executive director of the Moreno Valley and Beaumont Chambers of Commerce. We also have with us Maria Cazares Reyes, is the Housing Practice Group Director for Inland County's Legal Services. As an attorney, Ms. Cazares Reyes has gained immense experience in landlord-tenant law. Before working for ICLS, Ms. Cazares Reyes also litigated numerous cases in dependency court and other areas of law. Ms. Cazares Reyes is also a licensed attorney in Arizona and California. So now that we have introduced our panelists, we will begin this morning with opening statements from each of our panelists. After, we will move into our panel discussion, whereas panelists will be presented with a question, and the other panelists can add any additional information if they would like. Attendees at this time are in listening mode only. If the attendees have any questions, please enter them in the Q&A panel at the bottom of the screen. At the end of the panel discussion, we will open for public questions. If you would like to ask your questions live, please indicate so in the Q&A panel. You will then be taken off mute to ask your question. We will answer as many questions as we can. The virtual town hall is being recorded for later broadcast. I would like to invite Richard Lemire to begin his opening statements.
Right. Well, thank you, Jamila. And the Fair Housing Council of Riverside County is a nonprofit housing counseling agency whose primary mission is to prevent discrimination in housing. The Fair Housing Act was signed by President Lyndon Johnson in 1968, 1 week after the assassination of Dr. Martin Luther King. The Fair Housing Act prohibits discrimination in housing based on race, color, national origin, sex, religion, disability, and familial status. These are called protected classes, and the state of California has added an additional set of protected classes that are protected by state law. Fair Housing Council of Riverside County identifies discrimination primarily through the phone calls that it receives. We receive an average of about 60 to 90 calls daily at our 3 offices in Riverside County. And when discrimination is alleged or uncovered, Fair Housing Council of Riverside County investigates the complaint and then refers it to an enforcement agency, either the Federal Department of Housing and Urban Development, the California Department of Fair Employment and Housing, or a private attorney. Fair Housing Council of Riverside County is not an enforcement agency. Our agency provides fair housing services to the County of Riverside, as well as 10 cities in the county that receive Community Development Block Grants, or CDBG, directly from HUD. These are called entitlement communities, and the city of Menifee is one of the entitlement communities that we are contracted with, and we really appreciate that relationship. Through the Fair Housing Initiative Program, private enforcement initiative that Jamila spoke of earlier, or FHIP Grant, Fair Housing Council of Riverside County conducts housing discrimination audits and tests, which can result in discrimination cases being referred to either HUD, the FEH, or private attorneys. And another component of the FHIP grant is education and outreach. These town hall meetings are being conducted under the auspices of the FHIP grant, as well as providing service to our contracted community. Fair Housing Council of Riverside County is pleased to have you join with us today.
Thank you for the opening statements, Mr. Lemire. Now I would like to invite Edna Lebron to present her opening statements.
Well, good afternoon, everyone. First of all, I want to thank Fair Housing for allowing this City Hall virtual meeting. City of Menifee is fairly new city still. We were only established in 2008, and I'm hoping that with this virtual meeting, hopefully we'll be able to answer some questions for our residents of the City of Menifee. Thank you.
Thank you for your opening statements, Ms. LeBron. I appreciate that. Last but not least, we have Maria Cazares. Please give us your opening remarks.
Good afternoon, everyone. As mentioned before, I work for Edna County's Legal Services. We are a nonprofit. We serve many areas of law. I'm specifically the director for the housing group. So in the housing group, we mainly focus to serve those who are low income, seniors. Our main focus is to help those who are fighting illegal harassment by landlords, unfair termination of subsidized programs. We help through many issues that involve housing, whether that be eviction, repairs, reasonable accommodations. Altogether, to qualify for our services, anyone could feel free to call our hotline, which is 1-888-245-4257. That is the best way to reach our team. And from there, we will be able to qualify you. If you qualify, we will be able to provide you with as many services as we can give.
Awesome. Thank you for that, Ms. Cazares-Reyes. I appreciate your opening statements. So, Fair Housing Council Riverside County has gathered certain questions that have been received by our callers. The questions will be asked to each of the panelists and then open for discussion between the panelists. If any panelists wish to add any information, please feel free to do so. So I would like to start with you, Mr. Lemire. Can a landlord, since COVID-19 began, has there been any emerging trends in terms of discrimination or desperate impact?
Well, yes, we have noticed an increase in particular in discrimination and harassment issues against females, single females in particular, and women of color. So that has been a trend that has emerged very possibly as a result of the fact people are at home more and have more relationship and availability, just being around different landlord, maintenance people, or whatever. And so we've had an uptick in that type of complaints. Also, we have the usual complaints on mental disability, but physical disability complaints have come out too. Again, probably just the fact that more people are home and it's an uncomfortable situation for people of those particular protected classes. So the trends are it's disheartening to see that, but that's why Fair Housing is here, and that's why the Fair Housing Act is there to protect people.
Thank you for that, Mr. Lemire. I really appreciate that information, and you're correct as well. Now, Ms. Cazares Reyes, what exactly does AB 3088 cover, and what must a tenant do to be covered by the AB 3088?
Yeah, for sure. So AB 3088 covers a lot, but to keep it brief and simple, I'll explain. I try to break it down into categories so it could be simplified, but of course at the end, anyone's willing to ask questions. So the main thing about AB 3088, it focuses on non-payment of rent cases, but it also added some additional protection to what type of cases could be grounds for eviction. So the first topic will be non-payment of rent cases. So AB 3088 focuses on cases where rent wasn't paid after March 1st. So this is not a protection that covers any cases before March 1st. The idea is there is some kind of idea that prior to March 1st, anything that was non-payment was probably not considered any or due to the COVID situation. So any payment that wasn't made from March through August 31st of 2020, for those cases, the protection is that a landlord cannot file to gain that money until next March. So in March 2021, they can actually start filing for that funds. That doesn't mean that they can never get the rent. It just means not right now. So the government does kind of understand that tenants are going to be put in a tight position for a while. The second protection is for those cases where rent wasn't paid from September through January of next year. So for those cases, what the law says is tenants are still expected to pay 25% of their rent. They could do it monthly, or they could do a lump sum at the end due by January 31st, 2021. Just like the previous case, landlords will have the ability to later sue for the whole money owed to them. But if the tenant pays a 25%, then they will not be evicted. So the follow-up question to that was, how do they get these protections? So tenants, as soon as you get served with a 15-day notice to pay or quit, you will serve not serve, so it doesn't have to be through a process server, but you will give your landlord a certified letter saying that you have a COVID-related hardship declaration, and that due to COVID, you have some kind of hardship to pay rent. I know there was a follow-up question later, specifically to the declaration, so I'll wait till then to answer the specifics of it. But that is the way you protect yourself. You file the declaration, and the landlord cannot evict you as long as you comply with the 25% rent paid. The second main category to this is that the AB 3088 allowed to create some kind of limitations of where the landlord could file an eviction. So as some of you may know, prior to COVID, a landlord could evict anyone for any reason as long as you were out of your lease and provided proper notice. But at that time, they didn't have to give you a reason. They could just evict you as long as, like I said, you were out of your lease. Now, what this order is saying is the landlord could only evict you for just cause or no fault. So the no cause, an example will be if you violate your lease. So unauthorized guests, failure to allow the landlord to come into the premises with proper notice, nuisance, that will be just cause, anything that puts the public as a safety risk, that will be grounds for eviction as well. The no fault eviction will be in cases where the owner is thinking of moving back in. I know there's another question coming up dealing with what about the owner wants to sell the property, so we'll move to that specific later. But for now, it does create some kind of limitations. Now, it is important to know that these protections only will apply up to January. So no, after February 1st of 2021, we're not really sure if they will extend the protection or not. As of today, they will not be protected past February. That means that at that point, the previous laws and governing housing will apply.
Thank you, Ms. Cazares Reyes, for breaking that down for us. We really appreciate that. You brought up rent That will be my next follow-up question in regards to for Ms. Lebron. Now, Ms. Lebron, what programs or resources do the city have in place to plan to put in place for those residents struggling to pay rent or catch up on past due rent?
So currently the city does not have a program, but recently we received the CDBG CV3 grant from CDBG, and we are thinking about possibly putting a program for our renters here in Menifee. Hopefully that will help them. But as of right now, they would have to go to through the county or the www.unitedlift.org to see if they can get some help with their rent.
Thank you for that, Ms. Lebron. I appreciate that information. So going back to our callers in regards to the questions that they have for us, my next question would be for you, Mr. Lemire. Can a landlord say they are selling a home as a way to evict a tenant?
Well, that is, one of the, as I said, the no fault that Ms. Gutierrez Reyes was talking about, and I'll let her kind of flesh a little bit about that. But that is an acceptable way to take over a property. And I know that the writing of the law will, mention if taking things off the rental mark or whatever, but. If they give a 60-day notice, which would be the typical notice if this protection wasn't in place, the AB 3088, the way it was before, you would still get a 60-day notice. They could still, go forth and process that after 60 days. And what we usually advise the callers that call in face of the situation is, well, yes, you are put on notice. This is it is in your best interest to be looking for some place to move because obviously they want to change that situation. But it's a very difficult situation right now for people to find housing. As far as just even shopping for apartments and units, rental housing because of the COVID restrictions. Rental offices aren't open. People are, they're not showing properties or whatever. So it is difficult, and many of these people may not be able to relocate after 60 days. And then but they do then have that facing a legal challenge. And Mr. Sarah Reyes, could you maybe go into what the legal situation would be for those landlords that would like to do that?
Thank you for that, Mr. Lemire.
Now,
in regard,
I was just asking if Maria would answer that question.
Yeah.
Oh, sure, of course.
All right, I just want to add that so everything was correct. I would like to say that in AB 3088 does kind of add some little exception to that. So selling of the property is grounds, but they also specify that only if the new owner wants to move back into the home. So that is a protection that a lot of the landlords don't know. So I did add a note that normally what we advise the clients is that will be some defense we could bring up in the eviction if it gets to that point. But what we also recommend is for the tenant to take initiative and write a letter to the landlord, letting them know about AB 3088 and how they are protected if the new owner is just out for the business of renting himself. So just to clarify, the situation will be if a family's out looking for a home, they find this home and they want to move in. This is, we don't want to punish the new family who's also going to be in a position where they themselves are looking for a home. But this protection would be for those cases where maybe there's a new owner who's also looking into being in the market and renting the property. That would not be grounds for eviction. So it's going to be case by case, but there is that small exception. So if tenants kind of have a feeling that the new owner is going to be a corporation or somebody in the business, they might want to write a letter to them just so they know that they're aware of the rights.
Thank you for that, Ms. Cazares Reyes, for breaking that down. I know there are confusions of questions. I know we receive them all the time, so I appreciate you doing that for us. Now, my next question for Ms. Lebron: is the city looking to restrict rental increases at this time, or simply follow the state law?
And that's the simple question. We're just going to follow the state law. We don't have any jurisdiction in regards right now to doing anything ourselves. So we just want to keep it simple by following the state law.
Thank you for that, Ms. LeBron. I understand that, of course. We want to keep it simple, don't want to confuse anyone. And with all this information that we do receive, it's best to just keep that one information coming in through the state broad, as so there's no, exactly.
Absolutely.
Yes, thank you for that. So my next question is for you, Mr. Lemire. Is the AC, the air conditioning system, a requirement?
Well, actually, believe it or not, in the state of California, air conditioning, unlike heating, which is specifically listed as a necessity for habitability, air conditioning is not one of them. But that's not to say, though, if there's a broken air conditioner, that a landlord is not responsible for fixing that air conditioner. If that air conditioner was working when they took the property, in a lease or a rental agreement or whatever, that air conditioning goes out, that is a landlord responsibility to get that air conditioner working back again. And with the hot summer that we had, it is not something to be taken lightly, because health is involved in many cases with people that are dealing with the heat. So air conditioning is in the same category as any other types of repairs that landlords do need to make. And the tenant is always advised to immediately put their request in writing. There's so many times, you're trading phone calls, text messages, emails, or whatever. But if you put that in writing, go to the post office, get it certified mail, then you actually have a starting point of your complaint. We always advise our clients to, take that extra step to send the certified letter. The landlord has 30 days to respond to a repair request. But once again, if it's hot and it's at air conditioning, it could be a lot shorter period of time. Certainly maybe as short as 3 days. And you just need to be persistent and to to deal with the landlord. Unresponsive landlords, as we sometimes say, there's no law against bad landlords, but they do have to respond to these. And so many times, unfortunately, and we hate to have to see it, but it goes over into legal if they don't properly respond, because that health is involved. But so, in answer to your question, on the state law does not say air conditioning, but in reality, yes, it is responsibility.
Thank you for that, Mr. Lemire, by providing the tenants the information that they need moving forward with those concerns that the tenants and callers may have. So I appreciate that information. Thank you. Now, my next question for you, Ms. Cazares Reyes, a little bit on repairs as well. So are there any established guidelines for landlords or property managers to following terms of completing repairs and or showing properties?
Yeah. So along the line, so currently there is no, I won't say protections, but there's no law stating that repairs shouldn't be done, or that anything that excuses the landlord from doing repairs. So nothing has changed as to those laws. So landlords are still expected to be doing timely repairs. As mentioned before, in general, 30 days is found to be reasonable, assuming that it's not an emergency. When it is an emergency, you have things flooding, that requires them to step up and maybe a day making sure that it is taken care of. It's going to be based on guidelines of the city, so social distancing, that's still going to be required. Like I said before, if I give my landlord notice that I need something repaired, and he gives me in return a 24-hour to inspect the home, and I don't allow him access, that could be grounds for eviction. So if we are requesting those repairs, keeping that in mind that the landlord could come in, I know there's going to be some concerns with COVID, and it's pretty reasonable. So we are expecting landlord to take those considerations, coming in with the mask, if possible gloves if we know we have a sensitive member in the home. But there is no actual established guidelines under COVID protections for repairs. And it's the same for showing the house. So the same regulations that applied before, as long as they're giving us the 24-hour in advance notice, we are to allow them in. And if we don't, that could be grounds for eviction.
Great. Thank you for that, Ms. Cazares Reyes. I'm trying to say your name slow so I don't mess up on your name. But yes, I definitely appreciate you providing such information. We do get a lot of those calls as well. My next question pertaining to you, Ms. Lebron. Does the city have any programs for property owners to replace old and outdated or broken AC units? Many property owners claim they cannot afford or to replace or repair. So do we have any information for those concerns?
So the only program that the city has at this particular time is the minor home repair program, but that is basically for senior 62 plus, unless you're disabled, and you would have to own your home. And these are funds that we get from CDBG on a yearly basis. And they would have to be low or extremely low residents in order for me to help them with these repairs of their homes. And that's the only program that we have at this particular time for our residents.
Okay, great. Thank you for that, Ms. Lebron. Now, my next question would be for you, Mr. Lemire. How long, I know you went over the repairs in the 30 days for the repairs, but I guess how long does the property owner have to make necessary repairs?
Again, you know, it would be 30 days when receiving an actual written notice, and that's where where the clock starts. And you know, if it unfortunately then gets to go over into legal, at least then, you know, the tenant is protected by having started that process and formally made the request. You know, here in fair housing, of course, we receive so many calls of things like bed bugs, mold, and all things that are landlord responsibilities. And you know, against getting that clock started, and you know, sometimes there are options. I think you had a question that would go to Ms. Lebron regarding the city's code enforcement and where they might step in on issues like this when it is appropriate. So, Edna, would you address the?
Sure. The only time code enforcement would step in is if the actual tenant has a health and safety issue. So as it was stated before, air conditioning, unless it was broken beforehand, then of course they would have to fix it. But in all reality, they consider that a luxury item. But as long as the water fixtures or electrical, that sort of thing, that's when they would step in, because now that is truly a health and safety. Your plumbing, your electrical sort of thing is when they would actually step in.
Great. Thank you for that, Ms. Lebron. Now, in regards to refusing those repairs, my next question would be for you, Ms. Cazares Reyes. Now, what can be done about managers, landlords that refuse to do repairs? Many are using COVID as an excuse not to make those repairs.
Yeah, there's actually a few options available to tenants. Some of them are pretty risky. So kind of like mentioned by Mr. Lemire before, we always recommend that our clients give written notice as well, and always certified letter, because that's the main way we could actually start a case. There's nothing in the law that says written notice is required. However, we cannot prove when oral requests are made. And most likely than not, the landlord will deny that there was a request. So let's start by that. So the first step, we recommend tenants do the notice. As stated before, you wait 30 days for reasonable repairs to be done at that point. However, there are emergency cases. There's no law that says you must perform a repair within 24 hours when it's an emergency. So what we say is you have to kind of go based on what's reasonable. So can you live without light for a day? Maybe not so much. Can you live without water for a whole 30 days? No. So there is a reasonable expectancy that there are going to be some repairs that should be done less than 30 days. But in general, most of the repairs are 30 days. Once that is not done, there's two main options. One will be the tenant could do the repair himself or herself, but the protection of the law for the landlord is that it cannot be more than 1 month's worth of rent. So if we're talking about a repair that is $3,000 and we only paid $1,000 of rent, then we cannot fix that repair ourselves. So we're talking about almost minor repairs, if you will. So if you make the repair yourself after giving notice, you deduct it from your rent, always giving notice to the landlord before you do that. So there is a law that allows you to do that. So if the landlord was to file the eviction saying you didn't provide me full rent, you will be protected. That is the risky way of doing it. There is a law, so a lot of our tenants get a little bit stubborn because they know there's a law that protects them. However, that will be a defense to an eviction. So that's not an automatic, you're protected, landlord will not file eviction. You will still find yourself in court. So the way we want to prevent that, just because we don't know what the judge will decide, he still has to decide if this was even a repair that was necessary enough to excuse you from paying rent. So what we recommend is there is an option where you make the repair, of course, after giving notice, and then you could sue your landlord in small claims if he refuses to reimburse you for that repair. That is a little bit more work on the tenant, and then we are also very understanding that they might not have the money. We cannot pay rent plus fix the problem. So it is a little bit difficult when it comes to repairs and how much protection is given to our tenants. But there is a law. We just need to make sure that you keep solid records, because if we are finding ourselves in the UD, unlawful detainer court, this is what we need to prove to the court. One, that there was a necessary substantial repair that needed to be done. The landlord was given notice. He failed to respond or failed to repair, and thus we needed to deduct from our rent. So as long as we keep a solid case, it will be easier to win in an unlawful detainer. But from my experience, I could tell you that sometimes it's very difficult to build a case on the repairs, which is why we recommend the second option, which is try to do the repair yourself and sue the landlord in small claims.
Thank you for that, Ms. Cazares-Reyes, for breaking down as well as giving us different ways on how to approach that situation. Now, my next question would be for you, Ms. Lebron. Will the city limit or eliminate late fees for COVID-related late payments?
So when you say late payments, is that in regards to the tenants themselves, or?
Yes.
So I do not believe the city can get involved in regards to the tenant and landlord issues for their late payment. That's something Fair Housing would get involved if, there is any type of issues. But the city, I do not believe, can get involved in regards to the tenant paying late fees or deducting fees of any sort to the landlord. Does that make sense?
Yes. You mentioned earlier about United Lift as well. Do you know if they have late fees, if they include late fees for the rental assistance with that program that you mentioned earlier?
I do not. I'm sorry, I do not.
Okay, no worries. Well, thank you for that, Ms. Lebron. I really appreciate that. All right, so my next question will be for you, Mr. Lemire. Can a landlord turn off my power or lock me out?
Absolutely not. No, that is specifically addressed in AB 3088. You cannot do a lockout, changing the locks, turning off the utilities. If you're in arrears of rent, as a method to try to force the tenant out specifically is not permitted. And if that does happen, the tenant is allowed to call the police department and come out, and the police would have to restore, make sure the landlord restores these basic needs, and they're also subject to fine too. So, Maria, if you can kind of let us know what those specific laws are, but that is definitely not permitted.
Thank you for that, Mr. Lemire, breaking that down of different steps for us, which also brings me back to more of the legal way in regards of proper eviction that we receive from callers as well. So, Ms. Cazares, if a landlord or property manager attempts self-help eviction, what can a tenant do? And that's back to changing locks or disconnecting the utilities, turning off water, and so forth of that nature.
So actually this one is a very exciting protection on like repairs. So sometimes we feel like there's this law, but it doesn't really do much for us. With the self-eviction one, the law is very strict on it. It's actually covered by Civil Code 789.3. So if you look that up, it's very strict. So if anyone tries to exercise self-eviction by turning off the utilities, by locking or changing the locks, a landlord could be responsible to pay the tenant up to $2,500 a day. So it's in the landlord's best interest not to. I'm pretty sure in most of our cases that covers a whole month of rent in just one day.
Wow.
What protections we have is, again, kind of like with repairs. Right now, I would recommend that tenants write a letter to the landlord. Of course, in certain cases, you need them to turn back the utilities that same day. So calling the police, hopefully getting some kind of assistance. But for the civil side of it, so you will have the right to sue the landlord in civil court. How we start the process, I would say write a letter, an email, a text message, anything that we have in writing to show that you try to work this out outside of court. If the landlord does not respond right away, that's when we could start filing the civil suit. I could tell you that a lot of landlords are not aware about this law. So it's easy for them to think, oh, I need my money's worth. So if I evict this tenant and he leaves, I could get someone in here in a month. They're thinking about money. They're thinking about what is the easiest way for me to get this tenant out, replace them with someone who's gonna be paying. Once they realize that they could be responsible for $2,500 a day, I could guarantee you they're gonna come back and pay. So we actually do have a case in my department right now where we filed a civil suit for a landlord who turned out the utilities for the tenant. As soon as he saw what the complaint said and what he would be responsible, that same day he called us trying to work something out. So definitely, if you guys are found in that position, call my office, because right now and it's free services, so all the money, if we get anything, will go to the tenant. So that is a good way to prevent the landlords from even thinking about doing it.
Thank you for that, Ms. Cazares-Reyes, letting us know on the steps on how to go or what would be next. In regards to eviction, of course, there's that concern of individuals not being able to find a place to go forward from there. They have nowhere to move to. So that leads me on to my next question for you, Ms. Lebron. Looking forward, what plans does the city have for expanding affordable housing?
Well, that's a great question that you're asking at this point in time, because the city, as of recently, we're working on our new housing element. And actually tonight at 6 o'clock, we have our first workshop that I'll give you more information about that. And as I stated earlier, the city of Menifee is still a new city, 2008, so it really hasn't been established quite a long time. And before it was established as a city, it was known as a senior community, unlike now that it's a rapidly growing community with young couples with needed affordable housing. So we are hoping that with our housing element, that a lot of people will take the survey that's online and address their needs of what they're asking, wanting the city to do. And hopefully with this housing element, we can go ahead and hopefully, what's the word I'm trying to use? Hoping that we can bring these programs or new housing towards our Menifee residents is what I'm trying to say. So I encourage, highly encourage anybody that's within the city of Menifee or planning to be within the city of Menifee to please go online, our website, take a look at the survey there and address what your needs are, especially for affordable housing, so it can be heard, and hopefully we can bring those affordable housing units to our residents.
Great, thank you for that, Ms. Lebron, by putting that together for the residents there in Menifee. So my next question would be for you, Mr. Lemire. One of course, one of the questions pertaining to our callers. How do I know if I am being discriminated against?
Well, that's a very, very difficult thing sometimes for people to realize that they are being discriminated against. Sometimes it's very obvious, and it is, and sometimes because they will actually hear the statements of discrimination based on those protected classes from someone of the landlord, maintenance people, or people representing the management. And when those situations exist, we certainly invite them to call Fair Housing. They can also apply and file a case online directly with HUD or with the FEA with the state. But it's best to go through Fair Housing because we do have the opportunity to look at the complaint further and to help the complainant get their get the case better suited to turn to HUD. As we have a lot of practice and a lot of experience in filing cases with HUD, and we know what HUD is looking for, and we can ask additional questions to make the case stronger. But a lot of times there is in a landlord-tenant situation, there is discrimination, but they may not really recognize it. And our counselors are trained to ask questions that may reveal discrimination. Once again, on the protected classes that we spoke of, and in the state of California, California allows other protections that the Fair Housing Act does not allow, and it's very, very difficult to discriminate and to get away with it. But you have to know that you do have that you are being faced by discriminatory practices, and so we encourage you to call Fair Housing, and we encourage you to if you have even the slightest inkling that something is not right. And this not only for in-place tenants, but also for those that are searching for housing. You never know if a person in a protected class is calling and is told that something is not available, and someone from a non-protected class calls, it's available. And that's a discrimination that happens all the time, unfortunately. And we are able to investigate that. But if you don't realize that what you're being told is not available or is not going to pertain to you, be suspicious, be somewhat worrisome. It may not be a situation of discrimination, but there is always that possibility that it is. So we ask that if you feel any slightest bit of the possibility of discrimination, to please let us know, and we can help and work with you on that.
Thank you for that, Mr. Lemire. It looks like that is all of the questions that we have right now. So I'm going to go ahead in the Q&A panel and see. It looks like we have one question there. So I'm going to go ahead and read this question that we have for us here. It states here, do homeowners renting a room in their home that they occupy have different rules to follow regarding evictions? Is their tenant actually a lodger and they can simply evict with a 30-day notice? So Maria Cazares Reyes, what do you think about those questions? It looks like we got two questions there.
Yeah, so that was a little bit difficult, and it's going to be one of those that most clients hate hearing, which is it depends. We need more facts to it. So for example, if I'm renting a room to a roommate type situation, and this was an actual lease, or there was an expectation that it was going to be month to month, and more than just a weekend or Airbnb situation, then that is a tenant. So that same rules will apply to the tenant. Depending on how long they live in the property, that's how much notice will require. But the same protections will apply to that tenant right now as well.
Mm-hmm. Thank you for that, Ms. Cazares Reyes. I appreciate that. So as we wrap up, I would like to invite our panelists to present closing statements. We will be going in reverse order from introduction, starting with Maria. Now, so go ahead with your closing statements.
I just want to say thank you for giving us the time. I like this platform. So all the people out there could get informed, the questions. Just to finish up, I didn't get to really answer the question. I think there was a question someone asked about what is considered hardship under COVID related situations, even if they lost their job in a situation that maybe they lost in the beginning of COVID, they got another job, then is that still related to COVID? So just real quick, I wanna say that there's no specific situation. As long as we can relate it back to COVID, there's gonna be that protection under the declaration. So the way I see it, if you lost your job because of COVID, now having difficulty finding another one, when pre-COVID we would have easily found another job, that does apply to the financial distress. If you guys have any other questions, like I said, you can feel free to call Edna County's Legal Services at 888-245-4257. That's specific to the housing department. But if you do have issues with other situations, such as family law, consumer, call us and we can refer you to the right department.
Great, thank you for that. I appreciate that. Now I would like to invite Edna with your closing remarks.
Well, I also want to thank Fair Housing, and I will say, I'll repeat myself in regards to the workshop tonight, the housing element. For those of you that do not know what the housing element is, it analyzes the existing and future housing needs. So I urge our residents to go online and take the survey so that your ideas and input can be heard in regards to the housing needs of Menifee. Also, if you want to speak to the senior planner, his name is Doug Darnell, and you can reach him at DDARNELL@cityofmenifee.us, or give him a call at 951-723-3744. The housing element is done every 8 years, and it's crucial to know what our needs are, for our residents in Menifee. So if you take anything away today, is please go online and take that survey. So help us out on our housing element. Thank you.
Great, thank you for that, Ms. Lebron. Now, finally, Richard, I would like for you to let us know of your closing remarks as well.
Okay, well, again, I want to thank our fellow panelists here for answering questions that are very, very important to the public because it's a very confusing and very scary time out there. And we really are, are happy to have such excellent partners that we work with on a daily basis. And we'd like to all let everyone know that, Fair Housing Council of Riverside County, we're available throughout the week for you. We are open, our office hours open 8 to 5, Monday through Friday. We have 3 set offices in Riverside County, And our Executive Director, Rose Mays, has been our Executive Director since 1994. She has had a long-standing policy that our telephones are answered live here at the office. So you will not get a voicemail, you will not get a recording. You will actually be able to speak with a counselor at any time that you call in. And that is that's longstanding tradition of Fair Housing Council Riverside County, because it's all about service. It's all about service to people that are many times facing very, very distressful situations. We don't have the answer here. We have referrals that we can give out. Inland County Legal Service is a great partner, and so many of the things that come across are legal issues, and so we really value that relationship. But a lot of things are just letting people know what their rights are, what their resources are, and it's very comforting to answer that phone and have someone thank you at the end of the day for it. So that's why we exist, and we really appreciate serving our community, all of Riverside County, and we invite you to always call and know that we're always here for you.
Thank you for your closing statements, Mr. Lemire. Of course, I would like to thank the panelists. We would like to thank each of you for taking the time to spend with us. Hopefully, those viewing find this information valuable and that you've gained some insight resources that are out there. If you still have questions or would like to add any additional resources, reach out to one of us and we will make sure that you get the help and the information that you need. I would like to thank you again, and everyone enjoy the rest of their week. Bye.
Bye-bye now. Thank you all.